Hello, everybody. Welcome to Ask the Planman. I'm your host, Bruce Weinstein, and this week we're bringing you Mario Bai from the Summit Law Group to talk to you about wills, trusts, and estate planning. Ooh, sounds exciting. Ask the Planman's a weekly podcast where you, the public, can bring your questions or concerns, and we will be bringing in topical guests to help address, direct, and advise you on areas that you could take corrective action. Let me introduce Mario, a transplant from the New York, New Jersey area like myself, now down here in South Florida. Mario, welcome to Ask the Planman.
Thank you very much, Bruce. Thank you for having me on your show. I really appreciate it.
Oh, very excited to have you here. So background-wise, I've been doing financial planning, investments, and insurance work since the mid-'80s. And for me, having an estate planning attorney is paramount in my quick dial Rolodex. And so Mario and I have been working together, and we wanted to talk today about certain challenges that very basic level estate planning can be addressed, as well as maybe some more sophisticated. And then hopefully today we'll share some anecdotes of stories of success that I've done, Mario's done, and the audience can get their so what. And our so what, Mario, is why am I listening to these two guys? What's in it for me? We all have that with them. And so we want to give them their so what. All right?
Absolutely.
So what I wanted to start out with you today, and again, we'll just evolve the conversation best we can, is one of the biggest challenges when I was doing my seminars over the years and speaking in public forums is the volume of people with minor children that did not have a will. And so I was hoping we could talk about a little bit to kind of kickstart us today is what the ramifications are and why this is so important for a young couple. Doesn't matter when you start your family. I don't mean to say young versus old, but somebody who has young children under the age of 18. Let's talk about and share with the audience some so whats of why this is so important and why I was on a soapbox for so many years. So jump in on that a little bit. I'll shut up and let's.
No, absolutely. And I think that's a great topic to talk about, and it kind of introduces some different areas of conversation. I mean, and most in particular, like what is the difference between having a will-based estate plan versus like a trust-based estate plan? And one of the areas that a will and a will alone can address is guardianship of minor children. Like who's going to get guardianship? Who is the preferred guardian for the minor children as to the testator's perspective? Now, what's put in a will isn't going to suffice as guardianship. There's still going to need to be a court order, but the court is going to look at the document, the preference that's stated in the will as the preference that the testator would have had, and would give that great weight as to who they would appoint as guardian. It would take a large, a pretty high bar to surmount in order to be able to challenge that in court and say, no, somebody else should be a guardian. The court's going to give heavy weight to what is who are the people that are identified in the will. Now, that's not going to be done in a trust.
All right, so let's break that up a little bit. All right, and a lot of what I do over the years is decipher and interpret, from the legalese side to the layman side. So you threw some terms out there that I want to make sure everybody understands. No disrespect, but we want to make sure when you talk to your buddies from law school, they know what you're talking about, right? But the audience may not know some of these terms. So let's simplify a little bit. We've got mom and dad, and they've got a couple of kids under the age of 18, right? And so your normal course would be if one parent were to predecease the other while these children were young, assumably the surviving parent would take over. I mean, that's how most people view it. But where the concern is escalating and what we're talking about now is if both parents were suddenly gone, right? Car accident, plane accident, something really bad happens and both parents are suddenly gone, so that the surviving parent's not there to take over. And so what I've encountered, and this is what we're sharing, and you can give input on what you've encountered, is people presume, oh, my mother will take them, my sister will take them, and it'll just play itself out. And as you're saying, and I think you use the testamentary and, some words. So the decedent, the person who's died, needs to have a directive that says this is who's in place as a guardian, or as you mentioned, the word trust, whether there's a trust in place for the assets to go, in limbo till the kids are of age, of majority, 18, 21, whatever it is, right? So again, I don't want to confuse people with too much jargon yet, but am I representing that accurately, right?
Yeah, absolutely. I think you hit the nail on the head. I mean, if you have minor children, and if you're you need to think about, there might be a time that neither of the biological parents are around. There's a common accident, something happened, and it behooves the parent to have a list of people that they would prefer to be the guardian of their children in the event that neither of the biological parents are around. So where you specify that is in your will.
And now let's tie it in, because now the parents may have life insurance. Hopefully they've taken out life insurance when the kids were born or sooner, or they have a mortgage. So you've got assets to come into play as well, right? So it's not just who's going to be the guardian of the children, but now somebody had $1 million of life insurance. They had a $500,000 home. They've got a 401k. And all of a sudden, the inheritor of all of these falls to what we call the contingent beneficiaries, right? The primary was the spouse, the reciprocal spouse, and they're gone. That's why you list, here's another so what, everybody. This is why you have contingent beneficiaries on your retirement accounts, your life insurance, anything that's designating a survivor, you want to have a contingent. So if the primary is gone and that's your spouse, it doesn't fall to just your children. The last thing we want, Mario, is our 11-year-old to get a $2 million inheritance. Right?
Absolutely not, for many, many reasons.
Right.
I mean,
so let's so right there. So let's talk about what some of those reasons might be. Go ahead. Well,
absolutely. One reason and one horror story that I had seen was there was an individual, and for so he had two biological minor children. The mother of those children had died, and he married or he was marrying or cohabitated with a woman who had been taking care of the kids since birth till about 6 years old. So the kids were around 6 years old. This woman was living with them, but wasn't the spouse. And for whatever reason, on his life insurance, he had named his two minor children as his primary beneficiaries. And all of a sudden, he dies, has a freak accident, and the man passes away. And now the life insurance is looking to be payable to minor children, but the insurance company is like, we can't pay that out to minors. Either they want to hold the money, or the surrogate, in this case, was going to hold the money until the children were 18 years old, paying out at a fraction of a percent of interest. And it was untouchable because the other mother had adopted the children. The other woman had adopted the children. So she had an obligation to provide for the children. So she couldn't tap into the funds on her own until the children actually turned 18 years old. So it was this huge dilemma that there was over $1 million tied up in the county surrogate's courthouse and was unavailable to help raise these kids. They were able to get access for certain things, but it was difficult, it was cumbersome, it was just, and it, it could have been prevented with proper planning. I mean, that's, and that's what we're here to talk about.
Right. So Mario, you mentioned something I want to dive in a little bit deeper, and the will or instructions, right? Like I'm the last way for me to control anything is using my will or a trust, right? It's my final decree. And if I want to have money flow certain ways, and not go somewhere that, it may wind up, that this is where you have that opportunity to put your final instructions in there. Doesn't mean somebody won't challenge it. Doesn't mean the black sheep of the family is going to come home and want to sue because you cut them out. But this is what you're trying to accomplish. And I say this because I want to share, we're going to share some stories, something that happened within the confines of my career where, and you'll know the term, and I'm in a second marriage. It's a second marriage for my wife and I have two sons, natural sons, and I have a stepson. And so one of the things that I've talked with families over the years is a Q-tip trust, right? And so you could explain better what Q-tip stands for besides something you stick in your ear, but a Q-tip trust is some kind of designation where the assets go into a trust so that my wife can't cut out my children and I can't cut out her child, and everything that's going to be done is going to be under the decree of what this trust is designed to do. And so my backstory is that I had a client, second marriage, two children on each side, and I kept insisting to the gentleman who had the money to set up a Q-tip trust to protect his children in case he predeceases. And now the wife is going to screw over, excuse my language, folks, his children. And he refused to do it. He was with the woman for 50 years. You know, he trusted that she's going to take care of his children. Well, guess what happens? He died, and she did everything she could to corral all the money to her side and cut out his kids so that her kids could get the majority of the money wherever possible. So instead of it being 25% equal distribution, which is what he wanted, it became very lopsided where his children, I don't know what that is. Hold on. Somebody's trying to get on my computer in the middle of this. So this is a big challenge. And so again, basic wills. And then when you've got blended families, think the Brady Bunch, right? You got Mr. Brady and Carol Brady, and they each got their kids, and they fight over Alice. But the Q-tip trust.
The Q-tip trust is a qualified terminable interest in property. It's a way to pass money in a blended family situation. It allows the person who set up the Q-tip trust to direct what the surviving spouse has access to during her lifetime, and then where the remainder of the assets are divided and distributed to upon the death of the surviving spouse. Now, these trusts are very complicated because practitioners who don't really know what they're doing, and if you want to speak of horror stories, I mean, I've seen Q-tip trusts set up where the surviving spouse was given a power of appointment over the assets in the trust. So she had the ability to direct where those assets went upon her death to anyone in the class of her children or her deceased spouse's children. While in her will, she gave everything to her children. So it effectively cut out the decedent spouse's children by giving her this power of appointment inside the trust that was just buried in there. And it was a line, but it was there because some practitioner just really didn't understand, what that language meant and why it was there, and should it be there or should it have been taken out, but I mean, unfortunately, that's things that can happen. But those trusts are very powerful, again, in the blended family situation, because if drafted correctly, allows the decedent to have some, what we kind of call dead hand control over the assets after they've deceased. And one of the beauties of having trusts in the state of Florida is that they're allowed to exist for up to 365 years, unlike in some other jurisdictions where they're limited to a much shorter period of time. And that allows for real, what we call dynasty trusts, to have money stay in trust as long as possible. The longer it stays in trust, the more it's protected for the people, for the beneficiaries of those trusts.
Now, correct me, I'll elaborate a little bit more. My understanding of it is, so it not just helps as far as the directive. So let's say my kids don't get cut out, but let's just say I went first and the assets go into the trust for, my wife. And what if my wife remarried again? Right? So if I'm not protecting my estate and my heirs by using something like the Q-tip trust, and I just left her the money, and now she winds up remarrying, or she gets into an accident of some kind and somebody sues her or bilks her out of the money. She's now in, her 80s, and she's got the pool boy, that she's taken in, and he's figuring out ways to rip her off. Well, guess what? A Q-tip trust isn't going to allow that kind of penetration because she never really had the control, right? So again, there's these lessons that everybody's gone through in horror stories, but these are the reasons why, because there are sinister people out there, and obviously traffic accidents and other lawsuits come about that can get after that money. So.
Yeah, we talk about, when we talk about trust-based planning, one of the reasons behind using trust-based planning is to protect your money from what we call creditors and predators. I mean, and you kind of hit the nail on the head. It's like, you got the creditors and predators. You've got legitimate people who might have a claim for whatever reason, and then you've got those predators. It's the pool boy, it's the nurse at the nursing home.
She got like I said that one.
And we that's in one of my presentations, believe it or not. But it's true. I mean, these things do happen, and there are people that unfortunately do prey on the elderly, and it's unfortunate, but it is a reality. And if we can plan for contingencies like that, then we've done a good job, and there are ways to plan for that. So
there's plenty of episodes on Netflix to find out those kind of stories, right? Like they're making videos every day with that stuff. So let me come back a little bit, because I didn't get that question out that was in my head, and again, it's in the what could people do with this information? So let's go back to the parent 101 side, which is the basic will scenario. Ballpark. I mean, I'm not trying to be in your wallet, and it's not necessarily your rates, but what would you give as a range to the average family to get not a big fancy estate plan trust wise, but just a basic will? What would people be looking at from an investment, right? It's not a cost, it's investing in their family, but what would something like that run? What would people anticipate when they sat down with somebody for just some basic I love you wills?
Yeah, so for a range of price for an I love you will, which I can say would probably.
And I don't mean to put you on the spot, and if
no, it might be somewhere around like $550 to $850, somewhere around there, I would imagine. But I mean, it's almost borderline malpractice to have a planner draft an I love you will. There are practitioners out there who have estate planning as kind of an add-on to their practice. It's one practice area where they might do 4 or 5 different practice areas, and they might draft something like an I love you will. But for a lot of different reasons, like it's a disservice to draft a will like that, because for not much incrementally more, you can have an estate plan. If you think about like an estate plan with a full like revocable living trust and a will and all the other necessary estate documents might cost somewhere between, I don't know, $3,500 to $5,500, but gives you ultimately so much more features, that you can take advantage of. So that, you talk about simple estate planning, you're talking like 500 to 800, and somewhat of the most complicated estate plannings could probably be done, in that $5,500 range before you start getting to very specialized trusts. And that's where you start hearing about like real astronomical fees, but that's not the focus of what we're talking about.
So, and again, we're trying to make this kind of a step ladder of things for people. Is a young couple with a stay-at-home parent of some kind and only one income earner and a couple of kids. $3,500 is going to sound like a lot of money to them potentially. So I want to be clear that this can be building blocks like anything else that you do over time. Is you don't have to jump into 3,500. And let me describe what an I love you will is. Again, you and I are using terms that we throw around, but basically is I love you, Mario, here's my money. right? So an I love you will is basically making sure that your surviving spouse or partner is getting the inheritance from you. And so in my case, I'm leaving it to my wife, Robin. She's leaving it to me. I love you. Here's the money, right? And so with that, you can also prepare the guardianship for the children and at least get yourself some basic level protection, right? And so that $500, $800 range, most people should be able to get together. Now, as time goes by, as their finances have improved, if their assets become a little bit more sophisticated, then they can come back to you, right? I'm sure you do annual reviews or, some frequency of reviews with your clients is to make sure that they're up to date. What's changed? Oh, by the way, I just won this scratch off for $3 million I forgot to tell you about. Like, things happen, right? So whether you're working with your financial advisor, your insurance advisor, your tax advisor, your estate advisor, reviews are part of the game, right? Everything is obsolete the day we did it, right? And so you've got to keep up with it. So you can take what Mario's talking about. If you're at an entry level and that's what you can afford, well, get that, get that done, because it's your children that are going to be paying the price, and you're going to be gone, right? I mean, we say with life insurance, it's not for you, it's for them. So the estate plan, it's for them, right? It's doing the right things. And, we'll segue a little bit into the more sophisticated stuff where the tax planning, side of this stuff comes in, to eliminate estate tax, inheritance tax, and other things. So I don't want to blow the audience away with too deep of terminologies, but, I want to kind of give them some stacking pieces that, depending on who's listening, it's like, well, I need that. And, the other person's like, well, I don't need that, but I am that $3,500 candidate. Like, tell me more, Mario. Like, what else am I supposed to do there, right? And then the higher net worth person that might spend 5 figures, to have more sophisticated, trust work done and planning. Then, we want to be able to give people some direction and ideas. So we covered the basic, I love you wills, talked about Q-tips. Anything on Q-tips we left hanging that we didn't put a bow on? We're good.
Not really, no.
Okay. So for me, it ties into the insurance side of the space, is something that I've done over the years. And, hopefully we can speak on this a little bit for the crowd, is an irrevocable life insurance trust. And again, we're not going to get into the nuts and bolts, and I'm not taking the remote control apart to show you guys how this stuff works. But when you hit the button, it's going to go on, right? So we're not here for Mario and I to give you all the intricacies of this stuff, but to basically say, look, these tools work if you use them, right? And so you have to have confidence in your advisors. Right.
And use them correctly, right? I mean, and, have confidence in that your advisors are advising you correctly and making sure that you understand.
I point this at my car. My car's not going to start, right? So,
right. If someone tells you it's gonna, they're not telling you the right thing.
So let me elaborate. So we do life insurance work, right? So it's tied to estate planning. Let me tee it up a little bit. And so when you get people that have illiquid assets, farm, real estate, privately held companies, and their assets are not freely traded, or they don't want to give up control of those assets, right? A family-owned business. You and I have a landscaping business, and we've got acreages of trees and products that we're growing, and the land's worth tens of millions of dollars, and all the shrubbery that we're growing out there, right? And so we're father and son, right? So I'm your dad, and so I want you to inherit this. I think I'm older than you anyway. I want you to inherit the business and keep the business going, right? And so the problem is, when you inherit that, there's going to be potential, and in most cases will be, inheritance taxes due, and they have to be paid within a reasonable amount of time. So Mario inheriting the let's call it the farmland from me, he's going to either have to sell acreage, he's going to have to cash out other investments, he's going to have to take out a loan if he can get that kind of money, and he has to write a check for umpteen $1 million. And so what an irrevocable life insurance trust, and why life insurance is a tool heavily used in estate planning, a big piece of what we do, is it's a way to create liquidity, right? And the liquidity is, well, if Mario, again, I'm making this up, folks, if Mario is responsible for $10 million of taxes to inherit the family farm, well, his dad probably would, or me, I guess I'm the dad, we would put that $10 million into an insurance policy and put it into an insurance trust. Okay. And again, we're not going to get into the nitty gritty and talk about crummy and all that other stuff. But the point is that when the time comes, Mario is going to have an asset given to him that's inheritance tax free, income tax free, and he could write the check for the $10 million using the proceeds of that policy and pay the tax and keep his family farm acreage agricultural structure in place, right? I mean, that, again, I'm doing all the talking, you're nodding your head, but right? I mean, that's
the nuts and bolts of it. Absolutely.
Okay. So it's called Irrevocable Life Insurance Trust, and it's for liquidity purposes. And again, depending on what people's businesses are or their assets are, I mean, again, not to go political, but just think of Trump, right? Most of their value net worth is in what? Real estate, right? So if he's worth a purported umpteen $1 billion, and he's got, I don't know, 4 or 5 kids these days, and he wants the kids to have those assets and keep that Park Avenue property and this golf club and that hotel. Huh?
So at least 4 of them.
Right.
I'm sorry.
That's okay. And he probably won't see this. He'll be tweeting us when he gets done. What is he talking about? But again, in that regard, he's going to have a massive estate tax potentially owed, right? And now the kids are like, do I sell that golf club? Do I? And so what it also creates is what, Mara? A fire sale, right? A panic sale, ill-timed, illiquid, right? If it's stock, if it's Microsoft stock and the markets are down and now's not the time to sell the stock and they're forced to sell it and everybody knows that he's got to sell it, it's going to be a bloodbath.
Yeah, and that's the key. I mean, people are going to know that there's certain assets because, these aren't those kinds of assets. It's not a publicly traded stock. It's and unfortunately, in the example that you gave, there's a lot of value tied up in goodwill and the name itself, and that alone is going to be like, well, how do you capture what that is that's being passed down in the valuations of these businesses that use his name and license his name. So I mean, I foresee a very interesting scenario if when the time comes. I mean, we all pass it sometime. And I think one of the things I would want to point out, and you talk about the life insurance and how valuable it is to pay that estate tax. It is very important to put it in this vehicle, this irrevocable life insurance trust, because you want to make sure it is outside of the estate of the person whose life it's insuring. If it was just owned, like if my father just went out and bought a life insurance policy to pay for the estate tax consequences, it would be sucked right into his estate because he had indicia of ownership of it. And that's what putting it in the trust prevents and makes sure that it's outside of the estate so that the cash is available to pay for the estate taxes from behind or, from the back door, let's say. So it's important to have that vehicle, and there are other types of vehicles that do other things, but that's a great example.
Yeah, it's less used as it may have been before because the estate tax inheritance levels have climbed up. When I started, it was $600,000, right?
Yep, 675,
right? And eventually moved to $1 million and then, higher. So where is it today? It's 11 million.
It's 12 and change with the current adjustment for 2022. But I mean, I think everybody who's in the space predicts. I mean, first of all, there's the sunset. I mean, it is sunsetting in 2025. So no matter what, it's going back to the the 5 million adjusted for inflation level that was set prior to the enactment of the Tax Cuts and Jobs Act, or the TICJA. So there is a sunset that's already built in. So unless Congress decides to extend it, then we're going to have an issue come 2025.
So again, let me just, we're at 12 million and change now. It's going to revert back, if nothing is done administrative wise, it's going to revert back to 5 million. So anybody who has that kind of net worth is going to lose that $7 million ability. That $7 million today can be passed tax-free, inheritance tax-free, and come this sunset provision, they're going to lose that opportunity, right?
Absolutely. And we have to keep our eye on the political climate. I mean, there was a lot of talk of what was going to happen in the first term, in the first 2 years of Biden administration, that that was going to be dropped all the way down to 3 million immediately, because Congress can enact laws now to change that. So, I mean, if whatever happens in the midterms might spell something to happen in the next 2 years, we have to keep our eyes on that. And if there is an indicia, if there is some sort of indication that there is going to be a drop in the estate tax, then estate tax exemption, then it's imperative for people to just revisit their estate plans, because it would be important.
And again, we're going to run out of time today, and we're going to love to have you come back. But there's present day gifting people can do. There's ways to get money out of the estate. Again, we're not going to talk about it today, but I had done a very large charitable remainder trust case years ago where we gifted $5 million to a charity to get it out of their estate and created lifetime income for them instead, and used some ILETs, a lot of moving pieces. But it was an amazing case, and millions and millions of dollars were saved in asset protection, capital gains tax, inheritance tax. And, it was just something that, because of my background and training, I was able to solve for, and got them a solution that nobody else was providing them. And then we got the estate attorney back in New Jersey to put it together. So, it just bodes of, get a second opinion, have other people look at it. I mean, this client was working with a trust company that was not properly managing, diversifying their assets, and the charitable remainder trust solved some of that embedded capital gain problem. The trust wouldn't sell; they just wouldn't sell it. So anyway, I said I wasn't going to get into it, but I did a little bit. So tune in next time, folks, and we'll get into that story. So let me give a little podcast etiquette here. I've got to basically remind everybody to subscribe, hit below. Check out the description. You can see my information, Mara's information will be provided, anything we could do. Make sure you share and Ask the Planman podcast. Come back and see us each week. Mara will start to bring it to a close, but I always make sure I get my little infomercial out on there. Tell everybody where can people reach you? It's Summit Law Group. Website, phone number, feel free to share that now. And then we'll also put it in the description for everybody when they see the actual podcast.
I appreciate that. It's so Summit Law Group. We're down in Meisner Plaza in Boca Raton is where our headquarters is. It's 433 Plaza Real. We're in Suite 275. We have satellite offices. We have one on Glades in Boca Raton. We have one on Military in Delray, and several other offices throughout Palm Beach County.
So hopefully we're going to broadcast this outside of just Boca, Florida. So let's assume there are people all over the country going to listen. So they're not going to drive to Glades. I don't know where that is. But you're in Florida, New York, and New Jersey bar, right? So as people are transplanting down from the Northeast like we did, you can still be helping them, whether they're up there, they've got other colleagues or friends that need help up there, as well as those transitioning down here, right? But for people I know listening in Texas and Arizona and my friends in Washington State, so certainly you come to us or you find some people locally, but the whole purpose of this is to have people get professional help and make sure they're checking off their boxes and protecting themselves to the fullest. Obviously, affordability is a challenge for those. get the basics, get an I love you will to start, work into more over time, right? And if you have serious assets that require attention now, well, sunset was what, 2025?
Correct.
So that's per person, true?
That is.
All right, so let's do the math for everybody at home. For those playing in the higher end of the kiddie pool, it's 12 million per person, right? So a married couple can leave 24 million combined if properly done, and that's going to drop all the way down to 10. That's $14 million at risk if that sunset kicks in. And oh, by the way, Mario, what's the tax rate on $14 million of inheritance?
Let's just assume a 40% tax rate. I mean, just do that math, and that's at a bare minimum what you would be saving.
Right.
So
I mean, 50% is easy math, right? Just it's half, right? You're going to lose half.
Big half. Yeah,
if you live in New York, you're going to lose more than half, right?
Yeah,
you move to Florida, the state income inheritance tax. That's why people move to Florida, folks. You know, it's one of the friendly estate tax havens, right? So you're seeing again. We'll go on a little tangent. You're seeing all the hedge fund money coming down here. You're seeing Silicon Valley starting to come down here. You got Miami's a big Bitcoin NAFT hub now. There's a reason, folks. It's a tax friendly state. So you're worth a few $1 billion, and you could save 10% tax because you're getting out of your state that's going to have a 10% tax levied. That's a lot of scratch, right? That's a lot of coin.
Awesome. Well, thank you so much again, Bruce. I really appreciate it. Mario Bai from Summit Law Group, headquartered in Boca Raton, Florida. We've got offices in New York and New Jersey for our clients up there. Phone number is 561-726-6060. Website is www.summit.law.
Summit.law. Okay. Great. Thank you. All right, everybody. Listen, send us your questions. You can reach us at 844-PLANMAN. That's our toll-free number. You can go to our website, asktheplanman.com. You can email us at info@asktheplanman.com. Again, everything will be in the descriptions below. Mario Bai, thank you so much for joining us today. Please come back again soon. We'll expand on some of these topics and more, and hopefully the audience will be submitting some questions to us after they see this, and we can dive into those questions when they come back. So thank you so much for being here today. And everybody remember, come ask the plan man. If you're not sure where to go, what to do, there's no bad questions here. Come ask the plan man.
Need some advice.